Hey, so it's Ryan Locke, a personal injury lawyer in Atlanta, Georgia. And we just settled a case this week for $65,000 when the offer pre-suit was $12,000 and our client's former lawyer fired her, dropped the case because they thought it wasn't going anywhere. And so I want to talk about how you get from 12 to 65 through litigation. So, number one is you got to be in the case. The philosophical mindset, the psychological mindset is you got to be in the case for the long haul. You have to, when you file suit, you have to think, I'm going to take this case to trial if necessary, and so I'm going to do everything like I know I'm going to take the case to trial. Not like I'm going to file suit and then hope to get a quick settlement in, 2 or 3 months after they take our client's deposition, that kind of thing. The nitty gritty of what we did that really made a difference in this case. One, when we served the defendant, we also sent a copy by certified mail to his insurance. This is important because if the defendant fails to answer, like he did in this case, and and then he's in default, meaning that he can no longer contest the liability portion of the case, whether he's responsible for the car wreck and my client's injuries. In a typical situation, if the defendant doesn't respond, his insurance company will pull coverage. They'll say, you got served with this lawsuit, you didn't let us know, your contract with us requires you to let us know, and so we're not going to pay for the negligence in your car wreck anymore. But there's a Georgia law that says if you send them a copy of the complaint and the summons by certified mail within 5 days, then then they're aware of the lawsuit and they have to pay for it even if their insured does not answer the lawsuit. There are a lot of lawyers who don't do this because it really only makes a difference. I don't know, maybe like twice a year, maybe once a year, maybe once every other year. I mean, it's very rare that a defendant does not answer the lawsuit, but every once in a while it happens. And in this case, it happened, and it was a great advantage to us because the insurance was on the hook, and the defense could not challenge the liability. The second thing that moved the needle in this case is the defendant filed a motion to dismiss our case saying that he wasn't properly served. And we used a process server who is a little bit more expensive, but very thorough. And importantly, takes video of every serve that they do. Now, not every process server records video of when they serve a defendant because, again, most of the time it doesn't matter. It's not an issue. But when it is an issue, you're really happy that you have it. And we were really happy that we had it. And through that and some good motion writing, we won that issue, and our case obviously was not dismissed. The other thing that we did that really made a difference was keeping pressure on the other side at the end. And so the other side believed that they could continue to challenge proximate cause even though they were in default. That means that they believed that even though they did not answer the lawsuit, and thus every paragraph in our complaint was admitted, our requests for admissions that we sent, all those were deemed admitted, that the law says, hey, you can't challenge the liability portion. The only issue for determination is the amount of damages. They believed that they could argue that because the property damage in the wreck was very minimal, that it was not possible that our client was injured the way that she was saying she was injured. First, there's no reproducible scientific study that shows that the amount of property damage correlates with the amount of injury to someone in the car. So right away, the notion that because it's a low property damage, that it's low injury is baloney. Number two, that's also not an accurate statement of the law. And so what we did was we filed motions in limine around the time that we were submitting our consolidated pretrial order. And motions in limine it's saying that, hey, they cannot challenge proximate cause. They cannot challenge the reasonableness of the medical expenses because we specially pled that in our complaint. Again, something that not everyone does, but I like to put in the current amount of medicals when we file suit and also allege that the amounts charged are reasonable and customary. Again, it makes a difference, I don't know, once every other year, maybe. But when when you need it, you're happy that it's there. And so we were, full court pressing with these motions in limine, probably a little bit earlier than we needed to. And that pressure, I think, I don't know for certain, but I think that was really motivating the adjuster to come to the table with kind of like a highest and best offer right around after the consolidated pretrial order was issued by the judge. Their last move, they had stayed below 30,000 for the entire case until this week, and then they moved up to 65. So, like, is this the kind of case that is going to change someone's life? 65,000? No. Is this the kind of case that we go slap on a billboard? Absolutely not. I mean, it's not $1 million case. It's not a $10 million verdict. But these are the kinds of cases that we deal with every day. This is a normal personal injury case. This is probably the kind of case that most lawyers have a bunch of, where, the medicals are okay. The initial offer is shitty, and you got to decide: do you go to the mat on it, or like the other lawyer, do you tell your client, "Hey, I don't think it's worth it," and you drop them? You should hire the lawyer who goes to the mat on it. Anyway, our latest case, 65K in the books.